Well, welcome back to the My First Rodeo podcast, the show that asks really interesting, influential, sometimes famous people cool questions about their first rodeos, so to speak. And today is no exception. We have Judge Scott Makar, a judge on the 5th District Court of Appeal in the state of Florida, Intermediate Appellate Court before the Florida Supreme Court, which leads right into the U.S. Supreme Court. So really cool guy. In fact, he's argued multiple cases, more than most lawyers for sure, before the U.S. Supreme Court. Some of them really famous cases involving taxation, involving the enforceability and the legality of what's come to be known as Obamacare or the Affordable Care Act. He did that on behalf of the state of Florida under a couple of different administrations, and then went on to the 1st District Court of Appeal, and then on to the 5th District Court of Appeal just recently. So fascinating guy. He's got a PhD in economics, undergraduate degrees in mathematics. He's got a master's and maybe even an MBA as well. So fascinating guy. We're going to talk about a bunch of interesting things, including the cases he's been involved in, judicial philosophy. What is the status of the judiciary from a reputational standpoint in this society we live in nowadays? So I think you'll find that really interesting. But in the meantime, it's me alone, me without a co-host. I've been bringing in different co-hosts, really just people that I think are interesting in and of themselves. Maybe could even be guests on the show, but to help me carry the conversation, I'm going to continue to do that. But today it's just me. For a couple of reasons. One, because, and I don't talk about it a lot, but because my day job is being a lawyer, I felt like I was probably competent enough to talk to Judge Scott Makar, talk about the law, talk about his firsts, and maybe would take a little different vibe, a little less silly than some of our other conversations, which have both a serious and a silly component to it. But also because it's been a tough week for me. I got to be honest. My father passed away suddenly last week. And it was the week before his birthday. He was going to be 83 years old. A couple weeks before, I should say, my parents would have been married for 61 years. So that's a tough one. And so I'm just sort of getting back into a somewhat normal rhythm, or a new normal. And I know the death of a parent. My dad was, I think I said, going to be 83 years old. It's not an uncommon occurrence. 83 is a good number, but losing a parent, this is my first parent to lose, is a tough thing. So I know many people listening have lost one or both parents or other people important in their life. I've been spared a lot of that. Obviously won't. It catches up with all of us. So it's been a time of reflection. I lost one of my heroes, really my hero, in my father, and had opportunity to talk a little bit about that at his graveside funeral, real small funeral. My parents both Jewish, so got to return to and be part of some of those old Jewish traditions that, frankly, I wasn't all that familiar with. So that was a tough one. And what I realized, one thing in particular is my dad, maybe your dad too, told these stories forever, and they tended to repeat themselves. They tended to sometimes have him as the central heroic character. And they tended to change from time to time, maybe get a little more heroic, could be just forgot the facts. But, as I reflected on it in the days before his funeral and after his death, I was frustrated by those stories to some degree. And I realized that what frustrated me about it is that to the extent that he thought those stories were necessary to persuade me or anybody, but me in particular as his only son, that he was worthwhile or good enough, that he needed to be more heroic. That just hit me kind of heavy, that how could he not know how important he was in my eyes and how great he was? So, I don't think I left anything on the table, particularly in the last few months when it really felt like he was kind of giving up on life, to be honest. He was a really tough guy. He was a mechanic. He could do anything in the house. He could fix anything. He rode a motorcycle pretty close to the end. Was a very independent person, loved to travel by himself and just go do things. And, as he got older, his physical and mental faculties diminished, and he wasn't able to do those things. And so, yeah, really was just a shell of himself when I saw him on at least a weekly basis. And I'm so grateful I had that opportunity. I'm so grateful for those months in particular, and really for our whole life, to be able to tell him I love him when I saw him and talk to him. But gosh, if any part of him didn't know, he was my hero. Yeah, I guess what I'm saying is get out there and tell the people you love what you think about them. Don't leave anything where it could even fall into that category of regret, or where you could have lifted someone's spirits at a time where they needed it. Had some fun in the days after. Obviously tried to help Mom land on her feet and find her new identity as, a widow, a single woman. And that's been challenging, but also fun and good to know her in her own right. She's a cool person, and I've always known them as a couple. Now I know my mom, and I hope I have many years to get to know her better and to support her, because they've been good parents. But Dad's favorite song was Me and Bobby McGee by Janis Joplin, and wherever we went, whenever we saw a singer-songwriter, or heck, it could have been a polka band or anybody, he would find a way up to the front to ask them if they could play Me and Bobby McGee. So my sister and I and other cousins and so forth posted out anybody to play Me and Bobby McGee on the day of his birthday, August 11th, and to just think of him and that he'd be smiling down because his request would be granted. And we got a lot of really cool responses, a lot of fun versions of Me and Bobby McGee. And my cousin Andy, who you'll remember from episode number 5, who's the play-by-play announcer for the Tampa Bay Rays, he posted pop-up on the Jumbotron in the Tampa Bay Stadium and played Me and Bobby McGee. So shout out to Andy Freed. And the Tampa Bay Rays are doing pretty well. Not well, they're doing great. But they started off really big, and they're still doing pretty well. So that was amazing. So yeah, I've had a time of reflection this week. I know we all have that from time to time, and thought a lot about legacy and life, and happy to have this opportunity, the My First Rodeo podcast, to talk to some really cool people, to document their legacies, to get to know people that listen to the podcast, and to the extent you want it, give you a little bit of insight into me. And let's dedicate this episode of My First Rodeo to Allan Barry Freed, a good man and my hero. We're going to bring in Scott Makar now. Scott is a fascinating person in his own right. Guy has more degrees than most people have fingers, degrees in mathematics and economics. He was a lawyer at a very established firm. He went on to basically be the equivalent of a solicitor general for a large city, the city of Jacksonville, Florida, where he argued a lot of oral arguments both at the trial level and to appellate courts, and then was tapped to be the solicitor general, which is really in many ways a top lawyer within the state to, in particular, argue appellate cases, but not only. And he argued some of pretty significant importance. If that's not redundant, I think significant importance is probably not a good phrase. He would do better than me. The guy's a wordsmith. But he argued many cases before the U.S. Supreme Court, before being tapped to be an appellate court judge himself, both at the First and the Fifth District Court of Appeals. I think you're going to enjoy this little more subdued conversation than usual, but with a really cool, smart, and actually witty guy in his own right. So let's bring in Scott Makar. Well, Scott, welcome to My First Rodeo podcast.
Thank you. Excited to be here.
I'm glad you're here as well. I've known and followed your career for a long time. We've known each other for quite a while, and I've admired you from you in the bench, me from below the bench, beneath the bench. But
well, that's now. Way back when we were both struggling lawyers.
That's true. Struggling less than some, but you were certainly on a path to a lot of great things. That I was reminded as I refreshed myself with your background today. I mean, you have a pretty unusual background for the law, maybe for being a patent lawyer, but you've got the background in economics and mathematics. That's not every lawyer's background.
Well, those were things I was interested in, and it wasn't until my senior year at Mercer I was a math major. and trying to think, what am I going to do with a math major? So in my junior year, actually, I'm really excited about economics. Got turned on to economics and got an economics degree my last year at Mercer. And that really kind of turned the corner for me, because economics, I could see its application. I could see how the world really worked. Markets, supply, demand, pricing. It really explained a lot to me. And that's why I went on to get higher degrees in economics. And the math, of course, helped that, because so much of economics is mathematical.
Mm-hmm. That's interesting. So then how do you wind up on that path moving towards law? Obviously, economics gets you a little closer to how things are, how things should be.
Yeah. Well, I always wanted to go into the law. It was always a pursuit I had. And I did not really have much interest in political science or some of those traditional majors that lead into the practice of law. Once I got off on this tangent in economics, and it did become a big tangent because I went on to get a master's and a PhD in it. But once I got into those tangents into economics, there were classes in law and economics. And then when I saw the two coming together, it really lit my fire, because what I did is I went back and forth between one side of the campus at the University of Florida and the other side. I'd go to law school 1.5 years, and then I went to the other side of the campus, the business school, and pursued my master's and PhD, and also got an MBA in finance along the way. But both of those things, economics and law, to me, kind of came together and helped me have the tools and the analytical framework to look at the law in a different way.
Did you ever think along the lines about being a policy maker? Because that, to some extent, your skill set would lend itself to that, although you've been on the advocacy side. Now you're on the judicial side, and I want to get to your judicial philosophy and sort of how you approach things. But obviously judges generally don't make laws in a traditional sense.
Well, it depends on what era of jurisprudence you're looking at.
Sure. I think that's one you do not, you're not fond of.
Well, right. I mean, there are clearly areas of the law where judges, quote, make law. If there's a body of law regarding, say, tort, slip and fall kind of, and there's no law, I'll give you an example. This is more of a property rights thing, but suppose you and I are neighbors, and you've got a tree on your side of the property, and it's got some beautiful Meyer lemons, and the branches go over into my side of the property line. The lemons start falling into my yard. Whose lemons are they?
Sure.
And if there's no statute that tells you, if there's no precedent that tells you, a judge has got to decide. And in that sense, the judge is, quote, making law, but is making a judgment about a property right.
Mm-hmm. And then that becomes
Of course, they're
precedent.
mine. Of course, they are mine. But
Sure. We have a lot of lawyers that listen, but some that don't. So, I mean, that would be what we would call the common law, or the law that fills in the gaps where there aren't statutes, or a constitution, or what have you.
But I mean, if we're getting into judicial philosophy, I think generally, of course, we have different branches of government. Most people, I hope, understand there are 3 of them. And as a traditional matter, the legislature makes the law, the executive implements it, and the judges are supposed to be deciding disputes over what the law is. So, I mean, that's overly simplistic, but that is basically the structure we have and the structure I've followed.
Sure. Call balls and strikes don't determine the outcome of the game.
Well, I think highly of John Roberts in many ways. I think he's gotten a bad rap since the healthcare case came out years ago that we were involved in. And that was an interesting analogy he used, because rarely do I ever see a ball or a strike in the close cases. Usually what I see is something so close to the strike zone that a judge could call it either way. Yeah. It's in that gray zone.
Wow.
And if you have a really straightforward sort of meritless case, that's a strike or a ball. It's easily decided. It's like a wild pitch. That's a ball.
Sure. But those aren't getting appealed.
Well, I guess they are. Yeah.
And we're jumping ahead, but Judge Makar, Scott, is an appellate court judge, so he's not generally resolving issues of credibility. He's deciding whether something is constitutional or something else in reference to some established body of law generally.
Right. The court I'm on now is 12 judges, and we sit in panels of 3. So it's not me making a decision about whose testimony was most believable and that type of thing. It's more of the analysis of the record that we have, the factual record that comes up, and the application of the law. And we get a lot of close cases. I tell my colleagues, and particularly the new ones coming onto the court, that there's no right answer. And if you think you're going to come tell the judges of this court that you're right and they're wrong, that's the wrong approach. Instead, there's degrees of reasonableness. You might have a statute we're interpreting, and I see it this way, you see it the other way. We both see it in a reasonable way. We just have to decide which one's most reasonable among many reasonable outcomes. It's one of my pet peeves is that when a judge sort of thinks that he or she is just right and they have the correct solution, the correct answer in a case, when it's really not that straightforward. You have to really understand there's other ways of looking at it. And if I get 2 votes and you get 1, my reasonable interpretation is the most reasonable. If you get 2 votes and I get a dissent, mine is the least reasonable. So sometimes there's those difficult cases of interpretation where there's no one right answer. The one answer that comes out is right because the majority of judges voted for it.
Yeah, and that speaks to both the importance of putting good judges on the bench, and then it's a little, I hate to use this word, particularly in front of a judge, but it also makes outcomes a little more random than we'd like to think they are. But to your point, I remember when I was in law school in D.C. at Georgetown, and we were blessed to have a lot of cool people come in for lunches, and Justice Brennan was still on the bench when I was in law school. And I remember he came over once or twice, but one time I remember in particular, and there's all these, some sincere, some more pretentious law students wanting to ask a really esoteric and interesting question to Justice Brennan. And I remember this one woman who was asking questions, and Justice Brennan, who was pretty old at the time, kept just showing 5 fingers. And she, we're like, is he waving? What exactly is he saying? And to your point, his answer was it took 5 justices to write an opinion when there were 9 people in the court. And that's why it's written that way. If you're looking for magic as to why that verbiage versus another or what we were intending, that's just what it took to write the majority opinion.
Yeah. It took 5 to get the majority. It took 4 to grant certiorari in a case to have the case be heard by the court. So it was all about the numbers. And I mean, Brennan had an interesting reputation because I think it's a good reputation, a judicial reputation. But he was also known for sort of rewriting the Constitution, according to some people. And I always remember the great cartoon. I forgot who the cartoonist was, but he had Brennan sitting with a copy of the Constitution in front of him with a pencil in his hand, pencil or pen in his hand. He kind of marks it up. He says, I think it needed a little editing.
Well, I guess whatever side, and I hate to say sides, anybody's on nowadays, it seems like there's accusations of that about the other side, right?
Well, that's a larger conversation probably, but I think what the unfortunate thing is questioning people's motives.
Right.
That's come in. It's infiltrated every branch of government. And I think that we as a judicial branch, we would be better served to sort of put our blinders on to what's going on in terms of the political world and just be judges and act in that way and not be so, maybe agenda driven or driven by, its principles. Okay, it's okay to have a sound jurisprudential view and a principled approach to the law and all that. At the same time, we're serving people. I mean, we're not serving grand philosophical goals. We have people with disputes that want them resolved, and they're not really caring about originalism, or they're not really caring about whatever the popular jurisprudence of tomorrow will be. They want their dispute resolved in a fair and sometimes pragmatic way. They just want, it could be a business dispute or a family dispute. So don't burden us down with your heavy jurisprudential opinions. Just give us a fair, reasoned result.
We want to know what the result is, and we want to know how you got there, looking for some degree of rationality. Obviously, you'd like to win, too. But if you understand the outcome and understand how the judges got there and think they were fair about it, that's sort of how we have faith in the judiciary, isn't it?
Right, exactly. Because we're open. I mean, obviously, we don't always write. I tend to write more than others, perhaps. But we have our oral arguments publicly. There are archives. You can watch them on the internet anytime you want. Our decision-making, although it is done in private, I mean, it's confidential meetings that the judges have to decide the cases. We typically, in a close case, will write an opinion, or 2 if there's a dissent, or 3 if there's a concurrence, and you get the explanation from us. It isn't just like you lose or you win. We actually try to explain why and why. And if we disagree, why we think one person's view should prevail versus the others.
Yeah. No, it's such an interesting process. But let's get back to you. So we know what you're doing now because we just talked about it a little bit. But you have this degree in mathematics. You go on to get a doctorate, a PhD in economics, in addition to a master's in economics, I believe.
Right, and don't forget the MBA.
And the MBA, yeah, of course. It's, you must have had a couple weeks off and squeezed in another degree, and the law degree, of course. And then, what do you think you're going to do at that point? Are you always bench bound, or what were you thinking?
Well, the long view was always, yes, I want to be in the running for an appellate court position at some point. That was always my goal. And you can trace that back to when I was in high school. I went to Manatee High School in Bradenton, Florida. And one of the citizen and government days that we had, I was selected to go and watch argument at the 2nd District Court of Appeal, which is, the Florida Intermediate Appellate Court. And don't tell me why, but that day kind of got me excited. I thought, I really think I'd like to be an appellate judge. I mean, here I was, 16 years old in high school in Bradenton, and that vision kind of kept me on track, on path for the next few decades, 3 or 4 decades. So my game plan was to try to get as broad a experience in the law as possible, not just be pigeonholed into one area, and try to do everything I could get my hands on, from criminal to civil and you name it, appeals, trials. I was not a trial lawyer. I mean, I was more of a litigator. I was not very interested in doing jury trials because, I mean, you're probably good at jury trials, but
it's a bit of a popularity contest.
Well, I tell people a jury trial you have to be really skilled in so many aspects of human life to be a good trial lawyer, because you have to have the skills to put the case together. You have to have the skills to present it in a format in which you're recreating history for an audience. The jurors are sitting there wanting to know what's this about. And you have to recreate the history of the case through the witnesses and the documents and make it interesting. And then, of course, make it persuasive. So that's an incredible skill to do a jury trial, in my view. Yeah, some of it is charisma and likability and all that. But it also, there's other skills. The really fine trial lawyers are just amazing. I would call them, I won't say, well, maybe actors is a good, maybe too pejorative a term, but they're really good in telling a good story.
Sure, they're definitely storytellers, the good ones anyway.
Yeah.
No, I think that's right. And I think you would do those things well. I think there's I think you've got one of the, reputationally, in my observation as well, a really great mind. My guess is that you prefer to take long periods of time to develop your thinking and apply your history of thinking to a particular issue, and that shooting from the hip is not necessarily something you couldn't do well, but it's not your preferred choice of thinking. Did I say that about right?
Well, yeah, you're in the ballpark. I think it's, what trial judges do, like Judge Harvey J, and others that are on the court, most of my court are former trial judges. I mean, they have such enormous time pressures to make a decision, and we on the appellate bench, of course, don't. And I prefer that latter approach. I've been encouraged again and again and again to sit as a trial judge here in the Fourth Circuit, and I just feel like I know my skill set. And it's not a fear of being reversed. Even as an appellate judge, you get reversed. I've had opinions I've written as a first DCA judge that were reversed. Nothing yet in the fifth. So it's not that, but it's just I know my skill set.
Sure. Yeah, and I was speaking not just of being a trial judge, but a trial lawyer. The trial judge has to make some quick decisions for sure, and they can get revisited. The trial lawyer has to make decisions in the moment based on the decisions that the judge has just made in the moment, and then potentially take their case in a whole different direction or potentially different direction. Yeah. That's the that does not seem like that would be your highest and best use or your most comfortable place to be.
Well, yeah, because those trial lawyers, when they're confronted with an adverse ruling, they have to kind of recalibrate. Okay, now where do I go from here? It's basically like a curveball is thrown at them, and they have to figure out, okay, what's the next swing going to be? They have to have really facile minds that can change gears on the go. And I'm sort of more of a linear thinker, kind of flowchart things, and that just does not lend itself to trial work.
But it does lend itself to really good thinking and good writing and good advocacy, which you're known for. So let's talk about some of your first rodeos. You were the solicitor General for the state of Florida under two different gubernatorial or attorney general administrations, correct?
That's correct, yep.
And tell our listeners what the Solicitor General does, and then we'll get into some of the cases you were involved in, because you really were there in a time where Florida was front and center for the nation, and there were a lot of important issues being argued at the U.S. Supreme Court, and you argued a ton in a relative sense for a Solicitor General in the period of time you were there.
True. Well, as a preface to that, I spent many years at Holland & Knight, a law firm where I did quite a bit of appellate work, but it wasn't my sole practice. And then I went to the city of Jacksonville's general counsel's office, where Rick Mullaney hired me and allowed me to develop an appellate division there. So I ended up doing all the appellate work for the city of Jacksonville, the consolidated government, which was a wonderful job. Every time I see Rick Mullaney, I say, Rick, thank you for hiring me, because that was a wonderful step in my career. And here's why. Because I was doing all the appeals for the city, and that involved, it involves every issue you can imagine, because it's a consolidated government. When the time came where there's an opening for the Solicitor General, General McCollum had been elected, and he's looking for a Solicitor General. I had what I could actually portray as, I'm sort of the Solicitor General of Jacksonville.
Mm-hmm. That's about right.
Which was I was handling all the appeals, which is what the Solicitor General does for the state of Florida.
And Jacksonville's a big, complicated city. The city and the county are essentially the same thing. And so if you're not in Jacksonville listening to this or familiar with it, that's, like you say, a very big, complicated position.
Right. So it made the kind of segue from my job at the city in the general counsel's office to the attorney general's office working for General McCollum a little bit easier. The other little background bit of information is the Solicitor General position in Florida is unique, or was unique and still is unique, I believe at this time, which is not only does the Solicitor General represent the state of Florida in the appellate courts, that was the day job, so to speak, but you're also the holder of an eminent scholar chair at the Florida State University College of Law, the Irvin Chair, and you're required to teach there every semester, or at least every fall and spring semester. So I had been teaching at various institutions for many years here in Jacksonville, Florida Coastal, JU, UNF. So again, it was just a natural segue to go to become Solicitor General and teach at FSU. Mm-hmm. And it was just the perfect job. I mean, the Solicitor General job, I'll never have it. That is it. That is the top of the pyramid for me, because I was doing the things I love, the appellate work during the day, so to speak, and then teaching at FSU. And it was an interesting time, because we had to restructure the office. Maybe people who are listening to this may not remember, but Charlie Crist probably should have run for the second term of governor, but that was down the road. But what happened is he was at the Department of Education, Commissioner of Education, and then he became governor. And then, he became Attorney General. And then when he got elected governor, McCollum comes in as Attorney General. So everyone that was working for Crist went to the governor's office. All his lawyers in the Solicitor General's office, Chris Keyes and all those folks, they went to the governor's office. So when I went to the Solicitor General's office, there's one lawyer left. So I had to rebuild it. And that was a real challenge, because I had to start from scratch on that. But it was a great opportunity to get in really talented lawyers from around the state and build it up. And because I realized pretty quickly we were going to be doing a lot of appellate work, but we also did a lot of trial work. All these constitutional ballot initiatives, things like that are first filed in the trial courts. They were expecting me and my unit to go defend those types of challenges and so forth, and whether the ballot summaries are accurate and stuff like that.
Yeah. So, just basic question. How did you get we know who your client was. How did you get your cases?
Well, there certainly was more than we can handle at the state level. That's a good question. Some of the cases kind of came to us because the client base just had historically used the Office of the Attorney General. What was good, though, is that many of the clients we had, state agencies, actually paid an hourly rate for their legal services.
That's interesting. So you were sort of, they had a budget, or at least they had to find money.
Absolutely. And we had to go and get the work, just like you in private practice. So the Holland & Knight experience was another great experience to have, a private practice experience where you have to go generate clients, keep them happy, keep them informed. We had to do that a lot at the Solicitor General's office, because some of these agencies, they could go hire somebody else or use their in-house lawyers, things like that.
Interesting.
So the beauty of the office was that we had potential base of clients that have interesting issues, but our hourly rates were unbelievably low.
In a relative sense.
Yeah, I think at the time I could bill $350 an hour in the private world, but I think we were billing me out at like 75.
Wow, that is a bargain.
Yeah, so when the Department of Revenue comes and says, "Can you handle our case?" and I say yes, they're like, "Yes, $75 versus $350."
Yeah, that's incredible. Even at today's numbers, if you adjusted them, that would still be quite a bit cheaper, and some great lawyers you put together there. So, I mean, what were some of your first rodeos there? Some of the first interesting or big cases that you handled, and then we'll build up to some of the big ones that you handled closer to the end.
Well, there was a whole range of them that I had a list in my mind of things. There's a 6-month period in which we argued consequential cases in a trial court in Tallahassee, a trial court in Tampa. The trial court in Tallahassee had to do with an election law case. The one in Tampa in the circuit court trial level, it had to do, remember the wildfires were out of control back in 2007, 2006, 2007, around that time. And Florida had shut down all fireworks statewide.
Sure.
So these fireworks companies were not happy. So they had a case where they sued.
And many Floridians, I would imagine. It seems to be a rite of passage in Florida to blow your fingers off.
Yeah, right. Yeah, the emergency rooms weren't complaining.
Yeah, well, they generate revenue.
Yeah, right. Yeah. So we had to defend that case down in Tampa. And then we had some more election cases at the first DCA. And then I had a prayer case. A Pledge of Allegiance case in the 11th Circuit. It was a Florida statute that required the Pledge of Allegiance. You could opt out under certain circumstances. And it had the potential of going to the Supreme Court. So I had to argue that case, argued it here in Jacksonville, and we won. So that was the 11th Circuit, the federal court. So, and then I had a Florida Supreme Court case. I don't remember. I think it was another election case. And then we had the one at the U.S. Supreme Court. So I had 6 cases, real consequential cases in 6 months.
And what was the U.S. Supreme Court case that year?
Well, that was I think the focus point of today's discussion, which was a U.S. Supreme Court case came out of the 11th Circuit out of Atlanta. And it's called Piccadilly Cafeterias versus Florida Department of Revenue. And
Piccadilly Cafeteria, near and dear to most older Floridians' hearts.
Yeah, they were known for their cafeteria-style food. I remember as a youngster coming and my grandparents being all excited they're going to be able to take us to Piccadilly Cafeteria so we could get in line and you have your tray and then...
get a little cream corn. I remember they had some good cream corn.
Yeah. Well, as a young kid, you just cared about the desserts.
Oh, yeah. Jell-O, really colorful Jell-Os.
I mean, looking back on it, it's hard to understand why.
We were kind of eating like an assisted living facility.
Yeah, absolutely. The little Jell-O things with a little bit of whipped cream on it. Woohoo!
Yeah,
maybe a little slice of apple pie with a little bit of cheddar cheese on it. Wow!
Yeah, that was good.
So that was Morrison's Cafeteria, but it's a Southern institution, and that was Morrison's. And then Piccadilly bought Morrison's out.
Okay.
I forgot. I should have given you that little background.
I thought they were competitors.
Well, they may have been, but Morrison's time had come and gone, and Piccadilly took them over.
Okay, so what were they fighting about?
Well, Piccadilly's now in bankruptcy.
Right.
And there's a part of the bankruptcy code. It's I won't even delve into it. It's so boring. But it gave an exemption, tax exemption under certain circumstances. And Piccadilly had gotten this exemption from this property taxes. It's basically a document. It's called a documentary stamp tax. Most people have probably never heard of it, although they've probably paid it when they buy a property. So Piccadilly had gotten the benefit of that exemption under the statute. And the state of Florida, the Department of Revenue, my client now, felt that it was inappropriate. The statute that read properly would not allow for that exemption. So what had happened around the country, most people don't understand that the law can be very different. And I mean, the same statute, federal statute that covers the country, it can be interpreted in multiple different ways around the country. And if you go to one state like Florida, it'll be interpreted one way. You go to California, it's interpreted differently because they're in the 9th Circuit and we're in the 11th. So at the time, what was happening is we had a circuit split, which means there were 3 circuits that had weighed in on this bankruptcy issue. You had the 2nd Circuit, which went for our interpretation. You had the 11th Circuit, which went against our interpretation. Then you had the 3rd Circuit, in which it was a 2-1 decision against our interest in that case. So you had 3 different appellate courts, and they're split in the outcome. So we were approached by the Department of Revenue and said, hey, can you file a cert petition? I said, sure, we'd be glad to do that. Cert petition to ask the Supreme Court to take the circuit split. And I thought we had a shot, but it's a arcane bankruptcy statute. Are they really going to take it?
Mm-hmm. And I'll say for non-lawyers listening, cert petition would be a way to appeal to, in this case, I presume the U.S. Supreme Court, to resolve the difference of opinions, literally difference of opinions, of the various intermediate appellate courts around the country, including the 11th, which is where Florida lies.
Yeah. So in about my 5th month on the job as Solicitor General, we filed the petition with the U.S. Supreme Court around August,
to make the good people of Piccadilly pay more money.
Right. Yeah. They're unfairly taking advantage of this alleged tax.
Paying for Jell-O all those years and they're not paying their fair share.
Yeah. Well, it shouldn't. Florida has an interest in collecting these taxes, not having the federal statute misinterpreted and deny Florida the revenues. So we filed it. And then I remember very distinctly, it was early December of 2007, which was the year I was appointed Solicitor General. I came back from lunch and the assistant there said, Supreme Court called. I said, come on. Yeah, they called. They took Piccadilly. They accepted reviewing Piccadilly.
Wow.
And I said, I thought she was just pulling my leg. Yeah. But sure enough, they did. They did. And I had an email in my inbox when I got back that said they had accepted the case. Now, what is interesting in terms of the process, and you as a lawyer will appreciate this, the petition's granted in December. Our brief was required to be filed just a few months later, and the briefing process took only maybe 2.5, 3 months. And then I argued the case in March. So December to March, that's what, 3 months? I mean, it's a rocket docket.
Sure.
We accepted the case, fully briefed. The reply brief we filed, I think we filed the week before oral argument. So we argued March 26th of that year, 2008 actually now, and then the decision came out in June, near the end of the term. So it was a really fast process compared to most other legal processes. I mean,
but how about getting the result? How long was that process?
Well, it was from 26th of March until June 16th, so about 3 months.
Okay. That's not bad at all.
No, that's pretty fast.
And the result was?
Well, we won.
Piccadilly's now in bankruptcy, I believe you mentioned.
Yeah, we should have had a unanimous on it, but it was a 7-2.
I can't believe the documentary stamps put Piccadilly out of business.
No, they're fine. Well, it was probably their Jell-O gone.
Yeah.
But the takeaway from the case was interesting because it was my first U.S. Supreme Court argument, something lawyers like myself always dream of doing.
Big deal. They only have 100 or so cases a year. So
yeah, and back then it's down to a lot less than that. It's down around 65, 70.
That's amazing.
Yeah, so some of the pressure points going in was you have to acculturate yourself to how you practice before the U.S. Supreme Court. It's not like any other court. And also my opponent was a bankruptcy expert. He was a practicing partner doing a bankruptcy practice and argued many cases at the U.S. Supreme Court. And he taught bankruptcy law at Yale. So I'm going up against this bankruptcy law guru.
Sure.
So what made me feel better, though, is about 2 months before the argument, he was arguing another case at the U.S. Supreme Court. And it became the talk of the term for a while because apparently he had misrepresented some things or misstated things in his brief. And 3 justices just reamed him out. I mean, just embarrassing. I felt badly for the guy. And I never met him, obviously, at that point. But it was the talk of the legal world because no one had ever really been so excoriated publicly. And it's awful.
So you were riding that wave a little bit.
Well, put the fear of God in me.
Yeah, you don't want to make that mistake or level the playing field.
And our briefs have already been filed. And of course, I've tried to always make sure they're meticulous. But there's always that fear of, I wonder if we misstated something somewhere. And also, how are they going to treat him this time around?
Yeah, well, that's a challenge sometimes. I mean, there's misrepresentations and there's just advocacy that, whatever the judges aren't persuaded by. I have to say, I only get this with lawyers. When I interview lawyers, we tend to tap the table, which you're doing. Oh. And so to our listeners, if you hear thunder, it's not thunder. It's just Judge Makar Scott making a point.
Oh, so. Can I do that? So they hear what?
Yeah. So he's been doing that, and I was looking for a chance. It's hard to correct a judge, I will say. Okay. Yeah, but thank you.
Hopefully the speaker didn't pick it up.
We'll never know. If they did, it'll sound like emphasis. But anyway, so that's exciting. So you win your first U.S. Supreme Court case.
Yeah, the headline in the local paper, Jacksonville Daily Record, was Makar batting 1,000.
That's pretty good. I would imagine it got play outside of the Jacksonville Daily Record.
Mike, it's a bankruptcy case.
Yeah, that's fair, but it was only one of 60 or 65 that year. And it had a cool name, Piccadilly.
Yeah.
So that's catchy as well.
I'll tell you what was important about the case. Justice Thomas wrote the opinion.
Well, that's important too.
It wasn't a statutory interpretation. And keep in mind that, he's got his own unique way of interpreting things in terms of his jurisprudence that's, catching on and has caught on, become perhaps even a majority view of how to interpret things. This is a statute, not the Constitution. Long story short is, when I was preparing the reply brief in the case, this is our last document that we filed.
Right.
I did what I typically did in most big cases is I wanted to go, quote, off campus. I wanted to get out of the office. I wanted to go somewhere where I could be away from the phone and whatever.
Did you get a billionaire to give you a ride around the country? Because that's what Judge Thomas does, or Justice Thomas.
Well, we're not going to go there. But no, actually I went to something far more humble, which is I went to Jim and Milt's Barbecue in Tallahassee, which some listeners, I'm sure, will be familiar with. Which is just a wonderful barbecue place off, I forgot the name of the store.
Over in Tallahassee.
Yeah. So I went there at a lunch break, and the day the brief is due, we had a print shop in the basement of my building that actually prints the briefs. So I knew I had to get back. And long story short is, I had this revelation over lunch of this point I wanted to make, and I put it into the reply brief and filed the reply brief. And then when the opinion finally came out, Justice Thomas cited, I mean, he didn't cite our brief, but he cited this canon of statutory construction. And he said that the canon is decisive in this case. So I tell people, you never know what little nuggets you put into your legal filings that will be picked up by the court. And I had this revelation at Jim and Milt's Barbecue, put it in the reply brief, and it became the decisive point in the opinion.
That's interesting. That's what makes you sweat, both to wind up in that positive place where you've got the majority opinion citing favorably to what you said, and presumably your opponent, at least in that other one you mentioned, where he wrote some things and presumably thought about them as well, and then he winds up having a hard day at the U.S. Supreme Court, and you could end up on the other side of those sometimes, willingly or not, right?
Yeah, sure. I mean, it's not every day's a victory. So
so you have other days. In fact, one year, am I right, you had 4 arguments before the Supreme Court, U.S. Supreme Court?
Right, the 2009 term.
Which was a record, at least at the time, for solicitor generals and maybe for human beings.
Well, I'm not sure what the record is for human beings. I'm sure it's a U.S. Solicitor General who probably has the record, I think.
That's probably right.
I think Elena Kagan argued, the same term, I guess Elena Kagan argued some of the cases as Solicitor General, but maybe 5 or 6, something like that. But it was a big deal. We had 5 cases on the merits that year at the U.S. Supreme Court from Florida, and my office handled all 5. I did 4 of the arguments. The 5th one was done by a lawyer named Joe Jaco from here in Jacksonville. Yeah. And he was the Deputy Attorney General. And I always laugh because he did a Miranda warnings case out of Tampa. And it was a tough case, really tough case. And it was his first argument ever in any court.
Oh, wow.
He'd never argued in a trial, appellate. He never argued a case in any court ever. And this was his first attempt. And he won. I think he got a 7-2 victory on a tough Miranda warnings matter. And Justice Ginsburg wrote the opinion. So when we saw the opinion came out, it was Justice Ginsburg. We thought, Joe lost.
So he had his first case, and presumably was upholding what the law enforcement officers did in that instance. Yeah,
Tampa had a unique Miranda warning at the time, and it had some potential flaws in it. And the Florida Supreme Court had said it was unconstitutional. So Florida took it to the Supreme Court and we got it reversed. Or Joe, got it reversed. So he'd be a great person to come on here. That his first rodeo was an amazing one.
That's incredible. You've given me a good suggestion there for sure.
He just lives up the street here. So
understood. No, fine lawyer in his own right.
Yeah, absolutely.
So that's your first foray. What do you remember about that in terms of your interaction with the justices and the process? You've talked about leading up to it and the drafting, but the actual day of the argument, are you so prepared that you don't have time to be nervous, or is there just nothing like the nerves you felt that day?
Well, clearly you've got nerves, but the fact of the matter is, if you're prepared, you're probably not going to have a tough time with the justice. If you're prepared. If you're unprepared, you're going to get skewered. You're going to just get fried. But I felt pretty comfortable with our arguments, pretty comfortable with the law. I felt comfortable with how we had presented our position. And I felt we had the more reasonable position. So I had a sense of confidence about it. You get up before them and they're very close. In the court there, you're only, 3 or 4 yards away from the justice. You can see every movement of their face and their eyes. And
not a big room.
As courtrooms go, it's not that big a courtroom.
Sure.
but it's very quiet. And you're very close. So as I say, you can really pick up on from the body language who's going to ask the next question, because people kind of shuffle and get in position when they're ready to ask a question.
Right.
Justice Thomas shuffled a few times, and I thought actually he was going to ask a question, but it didn't happen. But all the rest had questions, some good questions. They were all prepared very well. Ginsburg particularly was prepared, had some really great questions. The only question I recall that I really couldn't answer was one from Justice Breyer. And I felt really badly because I'm not really sure I understood the question. And as an advocate, I probably should have said, Justice Breyer, I'm not sure I can really answer that question. I'm not sure I can give you a helpful answer. But I said something else. I forgot exactly what I said. But it turns out afterwards, people were saying, well, he always asks confusing questions. And Justice Breyer, he always asks long, semi-convoluted questions, and so it's okay if you didn't understand. So.
I assume you listened back to it. Did you ever figure out where he was going with it?
I'm not sure if I've ever listened back.
Oh, really?
Yeah, I'm like, I do not look forward to listening to my oral arguments. Just once it's over, move on. Because there's always a moment here or there where you have a slip. One of the cases I argued in the 2009 term, I moot courted it, I think 4 times. And I went to the Heritage Foundation. This was a juvenile sentencing case, 8th Amendment cruel and unusual sentencing case. And they kept telling me, don't use the phrase harsh. The juvenile had gotten a harsh sentence. I mean, life without parole, that's pretty harsh. And I kept using the word that was a harsh sentence. And they said, oh, no, you can't call it harsh because it's what the guy deserved to get. And it's put on harsh. You need to say that it was strong medicine. Ed Meese, former Attorney General, has told me, he said, you need to use the phrase strong medicine. Of course, during the argument, I accidentally used the word harsh. I guess that's why we lost. But I
thought you were going to say you used the term strong medicine and they shoved it in your ear.
No, well, I could have. Probably the strongest of medicine almost. I mean, it's not the death penalty, but life without parole is pretty tough.
That is some strong medicine.
Yeah, absolutely. So, but that was a term beyond all terms. But going back to the first one, it was good to have that experience. I learned the ways of the Supreme Court. I learned some of the customs and traditions, and it gave me a good wading in point, a good experience. So when 2009 hit, because we did 5 cases on the merits, but we also did 2 amicus briefs, Friends of the Court briefs at the Supreme Court level. And
were those on healthcare at that time, or
that came down the road a little bit?
Okay, that was just about when you were departing, correct?
Yeah, that was in the 2011. Okay, they're about 2010.
And you went on the bench.
Well, actually, I take that back. I think what happened was in the 2009 term of the U.S. Supreme Court, so that October 2009 to 2010, right in the middle of that. Of all those Supreme Court arguments, the so-called Obamacare legislation was passed, and Attorney General McCollum was at the forefront of that, and he had come to our office and said, could you draft a complaint challenging this? So right in the middle of all that, we drafted the federal district court complaint that ultimately was joined by, I don't know how many states, 25 states, 26 states, that ultimately became the healthcare case at the U.S. Supreme Court a couple years later.
The one that Roberts, at least in large part, upheld and found a couple of problems with.
Well, the taxation issue, right. That was the one that we were literally shocked with. I mean, because President Obama, when he signed the legislation, said, this is not a tax. Right. So when the majority came out with their opinion at the Supreme Court and said, this is a tax, it was like, wait a minute. Not that the president necessarily could bind the court on how they decided, but it became the case of the term that was most watched. It was historic. There was 3 days of oral argument in that case. I mean, Florida versus HHS, Health and Human Services. So there was a lot, that 2009 term, as I say, had a lot going on in the background. It wasn't like we just had the Supreme Court to deal with. We had Florida Supreme Court and Federal District Court in this case, a healthcare case, and so on. Yeah,
quite a busy period. You were there, and you were there for a while.
5 years, about 4 years with General McCollum, and then he ran for governor, didn't succeed there, but a new attorney general came in, Pam Bondi, and she retained me, and then about a year or so into that second term of Solicitor General, I got appointed to the court by Governor Rick Scott.
Yeah, an amazing accomplishment. One of the intermediate courts in Florida. You're one of the few people who've been on 2 intermediate appellate courts in Florida. Not because anything went wrong in the first one, but because of redistricting. And since you lived in the district that was now the 5th District Court of Appeal. You're now a proud judge on the 5th District Court of Appeal, right?
Right. As of January this year, I'm now, along with Harvey J., who joined me from the Duval County area. We're the 2 new first DCA judges who've now joined the 5th. We also have 5 new appointees to the court. So we have 5 existing 5th DCA judges, the 2 of us that transferred in, and then the 5 new. So,
right.
So it's a really new court. I mean, it's still the 5th DCA, but it doesn't cover the same territorial jurisdiction, and we have a whole new cast of characters.
That's not always a bad thing. But let's talk about your first rodeo at the first. What's that like? You've appeared before judges and justices. You've argued a lot of appellate cases. You've written a ton of appellate briefs. You've been at the U.S. Supreme Court and had some successes, and now you put on the robe for the first time.
Oh, you're talking as a judge. Versus a lawyer. I remember the first one as a lawyer. I argued at the first district. But
how'd that go?
It was a carnival, a fair where a carnival ride had some problems, and the inspector was subject to ethics violations, and I represented him on appeal and won. That was my first argument at the first district way back in the 80s. Frankly, I can't even tell you what the first case was at the first. I think the first case that I wrote an opinion in was some nondescript, boring summary judgment reversal, something like that, a 1 or 2 paragraphs, nothing kind of case. But by the time I left, I had written quite a few hundred decisions, including, I'm told, like 130 dissents.
A lot of dissents. That's one of the things you're known for. Tell us, a dissent, for those who aren't in the legal practice, is the opinion of the minority, whatever that is. In your case, it would be usually just one person, just be you. The other 2 apparently went the other way, and you're explaining why you disagree with them. And what is your purpose, and why do you write dissents?
Well, here's what I do in terms of process. If there's a case and we have a 3-judge panel and we have a disagreement, perhaps, we haven't totally fleshed it out yet, like exactly the disagreement, but maybe we disagree on the result. I've always written my opinions as if they're going to be a majority opinion. So if you read my dissents, they could easily just change a word here or there, and they could become a majority. So I've always written my dissents in a way that I'm hopeful that one of the other 2 judges will jump over.
It's very optimistic.
Yeah, well, right. I just write the case up the way I see it.
Right.
There's this misnomer. It troubles me a bit in the appellate world, appellate judicial world, which is that collegiality means you kind of go along with the other 2 colleagues and just join their opinion. Yeah. And to me, that's not the kind of collegiality I think that's appropriate for an appellate judge or any judge, really, to say you've got to call it like you see it. And if you're compromising how you see a case for the sake of a personal relationship with other judges, that to me is not appropriate. We can disagree. I tell people, let's just write it up. You write your majority, I write my dissent. You don't attack me, I don't attack you. You get these opinions where they're attacking each other, and it just kind of gets unseemly.
Sure.
So let's just write it. We see it differently. Write it up differently, move on. And sometimes my dissents actually might catch fire, and other judges around the state will agree with them. Other districts. That's always one of the best things that happens is when someone from another court says, well, they like your opinion better than the majority. Sure,
especially if it's the Supreme Court.
Right, when the Florida Supreme Court comes around. I've had a couple of those where I've been either the lone dissenter or joined with one other colleague in dissent on an en banc case. En banc means the whole court gets together, like 15 judges. And I've had 1 or 2 of those where the Florida Supreme Court has said, well, the dissenting view is the one we adopt. And that's really gratifying. Of course, you don't get that kind of result all the time, but I think it's important. I do a lot of concurring opinions as well, which those are ones that explain that I agree with the result. I agree with what the majority is saying to a great extent, but there's also this other aspect of the case that needs to be fleshed out a little bit, and I'll write a concurrence. And I do that to help the development of the law, because as a practicing lawyer, it really frustrated me that there wasn't some judicial writing out there on an issue of importance. And so I would try to fill the gap with a concurrence. It isn't the law. It's just my view. But it becomes helpful sometimes to practitioners or other judges. Judge Makar wrote this concurrence. I like what he said there. Let's follow this path.
Mm-hmm. And so for the average person, or maybe even not the average person, just somebody who doesn't run in the appellate opinion circuit, what is the value of those concurring and dissenting opinions to them? What should they see as the purpose for them?
Sort of a non-lawyer perspective?
Just to understand from a layman's perspective.
Yeah, I think it's basically saying there's other tools in the toolbox. Yeah, or maybe you get a decision and there's no tool, no explanation, or maybe a very terse explanation. Mm-hmm. And sometimes you need, I think, to open up a broader perspective in the case and allow the public and the lawyers and the litigants, the people who are most affected, to say, here's another way of looking at this. And yes, we've decided this issue, but maybe this other issue that's coming down the pike is affected in this way. So kind of give a little broader perspective of it. So non-lawyers, basically, I would say it provides a set of perspectives and tools for other judges and other litigants to rely upon.
Mm-hmm. And sometimes maybe even a subtle or not so subtle call to action for the legislature to do something different, to clarify something.
I, along with many colleagues, have from time to time said, hey, we have to rule this way, but maybe the legislature should straighten it out. Mm-hmm. That's a longer story, but the legislature writes a law.
Sure.
And that's not clear. I mean, not all, sometimes it is.
Right.
Most of the time, I don't think I'm going on a limb.
No.
But probably a lot of the time, if not most of the time, there's some ambiguity in the law.
Sure.
And sometimes it's intentional ambiguity because they don't want to have a law that they've got to pass a law that gets 50% plus vote.
Yeah, that's a good point.
So they have to kind of throw in language that both sides think helps them. Mm-hmm. And then they toss it to us, the judiciary, to figure out.
Right. A little bit of a punt or sometimes just facts develop that they hadn't anticipated.
Yeah.
Or, the drafting process at its best is still a messy one.
Yeah, right. So
there's going to be gaps.
Yeah, so that's where we come in and have to figure out what's going on here.
Yeah. Well, I hope this interview helps, obviously, our lawyers that listen get to know you better because you're a fascinating person and a great thinker. But also, I hope it gives some context because there's all this conversation, of course, and conversation is a kind word about, is the judicial process too partisan? Are judges too partisan? Is the judicial selection process too partisan? And, are judges making the law? And, the answer on all those things is kind of sometimes maybe, but it doesn't have to be. I think you're a good example of somebody who is a very independent thinker. And you approach things that way. And there's a lot of good judges. I think most judges are good judges trying to do good work. But certainly society has changed, the process has changed, and the mediated realities, sometimes to a good extent, sometimes to a not good extent, have a more heightened attention to the judiciary than probably we ever have. I mean, it's the least funded and least paid attention to branch, generally speaking, until we start paying attention to it. And we're really paying attention to it lately.
Well, I'd say it's the least understood in terms of the realities that go on in the judicial system.
Right.
I mean, it's no secret, I think, that those that practice before a large appellate court where you have 12 to 15 judges, it depends on which panel you get. 3-judge panel. You could have a 3-judge panel and one case decided the issue one way and 3-judge panel, another case decided a different way. So that's frustrating to people, but it's a reality of the system. And we try to get uniformity both within a court and across the state. And that's one of the functions that the Florida Supreme Court is supposed to fulfill. But there's so much law. I mean, how much law do you know? If I did a Venn diagram and say, this is the law, how much of it do you really know?
Yeah, I mean, let's just take the states I practice in, very little. Yeah, I was telling my son who's starting at Florida State University Law School in another week or so, when he graduates, he's probably going to know in some ways more law than I know now, practicing for 33 years. What I have now are some instincts and some senses of how things should be and a little knowledge about where to find the answers.
Yeah, exactly.
But no, I don't know the law.
Yeah, I tell my students, look, there's so many sources of law. You've got the Constitution,
sure,
not just of the country, but of all the states. Then you've got the statutes, federal and state. Then you've got regulations. Then you've got county and city. And then you go, the list goes on and on and on. And it's tens of thousands, if not millions of pages.
Sure.
That no one can possibly know even a fraction of that. So it's the principles. It's the broad principles of governance and the broad principles of how we interpret the law. And I really think one of the biggest issues we're facing as a judiciary is people seeing our decisions as being legitimate, meaning not that we're not legitimate judges, but that they want to feel like the decisions have a strong, independent analysis underlying them, that they're not being influenced by politics or an agenda or a particular worldview or a particular jurisprudence. I think that's the real challenge because I think people's perception, I mean, look at the U.S. Supreme Court. Its ratings have gone way down.
Oh, yeah. No, I think it's definitely a challenge. I'm not even sure it's a surmountable challenge. And yeah, then there's just the social dynamic that when you lose or when someone disagrees with you, and that's what happens in an appellate opinion or at a trial, if it's a judge or a jury, there must be something corrupt about the other side. There must be something wrong. Clearly, you couldn't have lost on the merits.
I'm laughing because one of my daughters does horse jumping, and I was sitting one day at the barn, and one of the other parents came up, and I don't know how the election kind of came up, all the controversy that was going on, all the litigation that had gone on, and I think she was basically saying, well, Trump had won the election, and I said, well, and so there were, I think, 60-something lawsuits where they were all disfavorable. None of them ever came up with anything. And she said, well, that's because all the judges are corrupt.
And this daughter lives in your house.
The lady didn't know I was a judge.
Oh, I'm sorry. I thought this was your daughter.
No, I'm sorry. She was out jumping horse. This parent, I'm sorry. The parent came up and said, she thought the election was stolen. And I said, well, what about there are all these lawsuits that failed.
Right.
Wow, all those judges are corrupt. And I said, well, I'm a judge.
Right. How'd that go?
Maybe an exception for you.
She didn't give much, did she?
No.
If you had ruled on one of them, she may have thought differently about you.
So,
I don't think that woman's perspective is all that unique, unfortunately.
No, I think that's prevailing.
And I know you do your best, to speak about the role of the judiciary and different philosophies and how to be civil, both with on the bench and as litigants. And I know you do your part to bring your own unique way of doing it. So Judge Scott Makar, Dr. Scott Makar. Scott, thank you for being on My First Rodeo.
All right. Enjoyed it very much. See you in the neighborhood.
See you there. Well, that was Scott Makar. Really an interesting guy. I think we only scratched the surface in terms of his judicial philosophy. And of course, judges, they can't talk about everything. They can't talk about cases that are pending before them. But Scott's certainly one of the more vocal people. So I encourage you to Google him and find out more about him. He is now on the 5th District Court of Appeal in Florida. So the court just below the Florida Supreme Court, which in many ways is the court just below the U.S. Supreme Court, and just an interesting person. I don't think you could really put a label on him. He's not, as I understand it, part of the Federalist Society. I know he goes to Federalist Society meetings. Lots of discussion out there about the role the Federalist Society has played in appointing justices to the U.S. Supreme Court and judges all around the country, particularly during the Trump administration, but for a long time. And I don't believe Scott is a member of that organization. I think he attends a lot of meetings of a lot of different organizations, and I respect that approach. It's certainly different, a different way to do what he does, which he does with a lot of passion. But very prolific writer. And just an interesting guy, with the mathematics background and just being a very pragmatic and linear thinker. That makes him a unique kind of lawyer, certainly different than, the lawyers that you see on the back of your phone book or the lawyers that you see on your television at night, the lawyers that you see in many courtrooms. Lawyers have to think quickly, and I tried to allude to it in the interview with him, but I know Scott's more than capable of thinking quickly, but his natural instinct is to think for a little while, research, write, and then come to a conclusion. And that is just a natural place for someone to be on the bench. That's a really good skill set to have, long attention span, obviously a knowledge of words, and just a really just a drive to find truths. I think we all try to find truths in whatever we do. I think we like to think that judges and justices and juries find the truth. But I think as we learned in the interview with Scott, it could be a little more random than we like it to be. It can depend on who your judge is, who the justices are. Certainly depends to some extent on who your jury is and, who the lawyers are. But at its core, the way the system should work is that the facts and the law should drive the circumstance. And I still believe it does most of the time, but in those gray areas, there's lots of opportunity for our implicit biases and for our instincts and for our prior knowledge and experiences and predispositions to come into play. So it's good for people to know that, and it's good for us to focus on that. It's not about people being good people or bad people, or overly political or overly liberal or overly conservative. Those things certainly come into play, but more often than not, it's good people trying to do a hard job and just having been wired in a particular way and approach things in a particular way. And it behooves the lawyers that appear before those judges to know what makes them tick so they can do the best job they can for their clients. Anyway, Scott Makar, another fascinating guest, telling us about some of his firsts on My First Rodeo podcast.